I have an expert with us today, Larry Landis, is Executive Director of the Public Defender Commission. And I think this is the third day in a row I've been in a meeting with Larry, which is, shows you how critical these type of issues are. He's with mental health issues on Thursday. We're with State Court Administration on evidence-based decision-making on Friday. And he's back here today to talk about public defenders and how we pay for those and what are some of the responsibilities of the county. So, again, appreciate him taking a Saturday off. He might have been golfing today in this great weather. He's still going to be golfing. So we're going to get right to Larry, and so please welcome Larry Landis.
Thank you for inviting me. It's nice to be here. Can everybody hear okay? Does this sound good? Needs to be up? Do I need to speak louder? Hold it closer? Test it. Hold it closer. Okay. Thank you very much. So I have 5 goals this afternoon, and I want to ask for your help on meeting those goals. The first is to help you understand why counties have the burden of paying for indigent defense. But first, let me ask you: how many believe and support the right to counsel? How many think it's a really important right to have? How many think that the state should be paying the cost of defense? Okay, less. We're going to talk about that in the separation of powers and how it got to be that counties are paying for it, as opposed to the majority of states where the state pays 100% of indigent defense. We are one of the minority of states where that initial responsibility for trial and appeals falls on the back, excuse me, on the backs of counties. My second goal is to ask for your help in persuading the Indiana General Assembly to increase state funding. My third goal is to encourage you, those of you from the 35 counties that are not in the state reimbursement system, to at least explore joining the reimbursement system and become eligible for the state reimbursement in non-capital cases of 40%. And my fourth goal is to save time for question and answers for you. And my fifth goal, as the challenging speaker after lunch, is to keep you awake. Louder? It's on. Testing. Wow, oh my goodness, yes. Okay, so let me talk about those goals again. No. Okay, so first thing, let's talk about how we got to where we are, and that would be not that one. But we can do that one. Thick, flexible. Currently, counties are responsible for the expense, providing an expense of public defense at trial and direct appeal. And then there are 3 state agencies. I am Executive Director of the Indiana Public Defender Council and have been since it was created in 1977. So I've been through 7 governors and a bunch of legislators, and I'm still here. Some of them are not. That's the council. We do training, publications, research, and policy stuff. We do not do any litigation. We don't represent clients. We support the public defenders in your counties that do the trial and direct appeal. Then there's a state public defender that does the state post-conviction for people who are in the DOC and do post-conviction representation where they come back to your counties, usually alleging your public defenders are ineffective and try to get some relief for their clients. They are state funded at post-conviction level. Then there's also, in 1989, was created the Indiana Public Defender Commission, which I will talk quite a bit about. But that is the body that sets standards and then reimburses the counties 40% of your expenses in non-capital cases and 50% in capital cases. So that's the 3 state agencies. We're all separate. State public defender is under the Supreme Court. The Public Defender Commission has 11 members. There will be a slide up here for that, but I can tell you real briefly. There's 11 members, 3 appointed by the governor, 3 appointed by the Chief Justice, 4 legislators, and 1 appointed by the Criminal Justice Institute, which is me at the moment. That's the 11 members. So it's a multi-branch agency, and it's been in existence since '89. The Public Defender Council is rather unique in that, and the reason I've been there for 40 years is because it's neither in the executive branch or the Supreme Court. It is governed by an 11-member board, 10 of whom are elected by public defenders, contract lawyers, and people who are regularly appointed. So that board of directors are elected by the members who are in that category, public defenders, and they hire an executive director, me, and I hire staff. So it's an independent judicial branch agency, which is rather unique, but the only other one in the state of Indiana is the Prosecuting Attorneys Council, which is similar structure. So, back to the question. Why are the counties responsible? We know that there's a Sixth Amendment federal guarantee of right to counsel. We know that the Indiana Constitution, Article 1, Section 13 provides right to counsel. So if the federal government is saying that everyone has to have counsel, why are they not paying? Right? That's a federal right. They're not saying that the states are obligated under the 14th Amendment. They're saying Sixth Amendment requires it. Same thing with the state constitution. It says every citizen in the state of Indiana, every person actually, it's been expanded, citizen or not, is entitled to a right to counsel. But they don't pay for it. Why not? So there's 3 cases that I'm going to talk about that really got us to where we are as to explaining in a separation of powers why the burden has been placed on counties. The first is this one, and it's rather simple. It held that prior to 1853, attorneys in the state of Indiana had to do, let's call it indentured servitude, a mandatory pro bono. The court could appoint a lawyer to either prosecute the case or defend the case, and they were obligated to do it without payment. Well, one brave soul said, no, I'm not going to do it without payment, and took the case up, and the Supreme Court said, you know, there is a constitutional provision, this Article 1, Section 21, says no man's particular services shall be demanded without just compensation. You can't do this anymore. So that was the first major case. The next one was a year later, Webb versus Baird, which many people mistakenly believe that this is the case that created a right to counsel in the state of Indiana. It did not, but it did some other things very important. And it's rather simple. Baird was appointed by a Tippecanoe Circuit Court to represent a person, and at the conclusion of the case, the judge says, for your services, I will authorize payment of grand total of $25. But the $25 did not go to Baird because the county auditor said, hell no, we're not going to pay $25 to a lawyer to represent a burglar? No, I'm not signing that check. So, Bard files a petition for a mandate to the Supreme Court, to the local court. Local court says, it goes to a different judge, which is the Court of Common Pleas. The judge says, okay, Webb County Auditor is saying, wait a minute, the judge has no authority to order me, right, an executive branch officer from the judicial branch to pay $25, and they don't have any order to even authorize payment to begin with, let alone order me to pay it. So the fellow judge on the Court of Common Pleas says, my brother judge does have that authority. Auditor takes it up. Supreme Court says, well, one thing, we said last year, you can't require a lawyer to do it without payment. And Circuit Court does have authority, but here's where we start developing the issue of who pays. Who pays? This is the entire, in the history of jurisprudence in the state of Indiana, this is the entire text that you will see deciding who pays. So I'll go slow. Defense of the poor is imperative. Resting somewhere, we have seen it's not devolve on the private citizen, must therefore devolve on public or some portion of it. It seems eminently proper and just that the treasury of the county, which bears the expense of his support, imprisonment, trial, should also be charged with his defense. That's it. No discussion of, is this a state responsibility or a county responsibility? Well, it was just decided, since they pay for the cost of trial and housing in jail, county must also pay. That issue has never been discussed since 1854. I'm waiting for a county auditor somewhere to say, hell no. We're not going to pay. Let's run it up the flagpole to the Supreme Court and say it's time you redecide this issue. So the other thing is that this court decided, judge didn't have authority to fix the amount. It's what we call in the law is the implied assumption issue. They got to prove that the lawyer was actually worth $25. You can't just assume they were worth $25. You got to prove it. So what happened then was the legislature enacted some legislation saying, well, all right, a judge may have authority to order payment, but if there's no appropriation, then the county's not liable to have to pay it. Because the fiscal body, the other third branch, right? We got a judicial, so far we've had the executive, now we got the fiscal body saying if we don't appropriate it, then county auditor doesn't have to pay it because there's no money in that fund. And that lasted for quite a while, actually. But these two cases together held trial judges do have inherent authority. And that's going to become important later. Inherent authority in a criminal case to appoint counsel. There is an issue about whether they have authority to compel payment and order it if there is nothing appropriated for that purpose. So we jump from there to whatever that is. Is that 86? 86 years later, for the first time, then we're back in Knox County, where two attorneys appointed, payment ordered. County auditor once again says, hell no. Okay, I'm just checking. You're an auditor, right? I kind of thought that resonated with you, right? Says we're not going to pay. It goes up. Supreme Court says that those two laws of 1902 and saying that you don't have to pay if there's no appropriation, unconstitutional. And held that it's the duty to pay for a lawyer in a criminal case. You can't have due process. You can't have trials. Judge has to have authority to pay, and it can't depend upon the will of the legislature or the county council. Now, what's interesting is they mention it can't depend upon the will of the legislature or the county council. Nobody has paid attention that they were kind of hinting, oh, by the way, would somebody raise the issue that maybe the legislature ought to be appropriating money for this purpose, not just the county council? And so 1940, that's where we were. Trial judges had inherent authority to appoint and mandate payment. Now, why is that important today? Because 23 years later after this, you recall Henry Fonda's case. Gideon, there we go. Gideon, he played Henry Fonda played Gideon. Gideon's trumpet took it to the U.S. Supreme Court, and that's where they declared the Sixth Amendment guarantees the right to counsel in criminal felony cases, 63. Then in 67, they decided there was a right to counsel in juvenile cases. A few years later, in 1972, they said there's a right to counsel in misdemeanor cases. Okay, so now that was kind of the flood that broke the dam in terms of now we've got massive number of cases where there's a constitutional right to counsel. And you've got the burden upon states and counties and courts to say, how are we going to provide this massive number of lawyers and this cost that's going to be borne by somebody when we haven't designed a system to provide this kind of volume and we haven't figured out the funding for it. So what most states did after 1972, once the Argersinger case came down and it was clear that you had thousands and thousands of cases where you had to provide counsel, they set about doing what you would do as a responsible elected public official. We have to figure out the structure and funding for this public constitutionally mandated service. The majority of states did that. Indiana did not. Now, the reason we didn't was we didn't have to, because we had this case law from 1940 saying trial judges have the inherent authority to appoint and pay. So we could rely upon that judge's authority to appoint, whether it's case by case or whatever. And then judges started contracting with a lawyer or a law firm to do a bulk of cases for a fixed amount. And that's how we got into the contract system. It wasn't just a case by case. So when states were starting to develop their systems, and many, as they started developing them, they decided, well, we got to do this on just like if we were going to design an education system statewide, or a mental health system, or a healthcare system statewide. We've got to figure out what services to provide it, how to do it, at what level, who pays, who funds it. We just defaulted to the inherent authority of the trial court and said, it's on your back, judges, you figure it out. And that's how it stayed. When I started out became a lawyer in 1973, and decided in 77, I was in the state public defender's office and wanted to finally confront the fact, and I went to my boss and said, I don't understand why we're spending all these resources on post-conviction. It's the ninth inning, there's 2 outs, the count's 0-2, and we decided to finally put some resources into indigent defense when we didn't put anything into the trial or direct appeal. Why are we spending all the money trying to mitigate or do damage control when we should be putting it at the front end to prevent the damage from ineffective assistance? She agreed, and we decided to start the Public Defender Council and do training and education and support services for the trial level people. But it didn't take very long to realize that's not moving the needle on quality, because the caseloads are excessive, the funding is inadequate at the county level, and we needed to get some resources to the counties. And that took a while to get that passed, but that's how the Public Defender Commission got established. The purpose was to set statewide standards and get state money to the counties as an alternative to a statewide public defender system. So that's what we started with. You will see in your handouts, there's one legal size, because I couldn't get it in print that you could possibly read into letter size. But it shows all of the counties that are getting money and how much they're getting since the commission started. And some of you might notice that your county is not on here, because you've not been getting anything because you haven't asked for it. But there's another handout that will help you understand the function of the commission, and that's this handout, which is an annual report that just gives a little bit of detail, tells you who's on there, tells you the funding through the levels. The funding started at $650,000 back in 1989 for capital cases only. Here's who's on the commission. As I mentioned, when we started with $650,000, it was death penalty only. And then the Supreme Court adopted a mandatory court rule, and that was Criminal Rule 24, and that said you have to appoint 2 lawyers in death penalty cases, you got to provide them adequate services, they have to have specialized training. That had a huge impact on death penalty cases. Before the commission was created and before Criminal Rule 24 was created, there was 50 people on death row. Now there's 11. And one of the reasons is that once the quality of representation started to increase and the lawyers had time to properly investigate and they had time to properly prepare mitigation evidence, as those cases went to juries and juries started hearing the life stories of the offenders and they were no longer so eager to impose death penalty, and they started imposing life without parole, which means in Indiana life without parole. It does not mean they get out or don't get out. So that was an alternative to death, and our death penalty rates started going down. And as they started going down and the costs started going up, prosecutors were less inclined to continue to file at the rate they had been filing. The other interesting thing over the years of the data that shows the decline in filings and the increase in cost was the number of cases that did go to trial. It was over 50% of the time, even though the facts in death penalty cases are always gruesome. I mean, there's never a factual defense. You know, they wouldn't be charging a death penalty if there's really a factual defense. They'd charge murder probably. So the fact that jurors, when they heard the facts, decided we don't need to kill this person, we can, and the data came back showing that it actually was cheaper to house them for 30 years than to pay the extraordinary cost of appeals for the next 20 years. So it's kind of counterintuitive. Everybody just assumes, why do we pay the cost of incarceration of somebody for the rest of their life? Leaving aside the whole issue of morality or whether you think the value of taking a life, it's cheaper also. So the fiscal is not on the side of imposing death. It's really on the side of maintaining life. But that's a consequence of the commission reimbursing, setting standards, and then the same thing they did in non-capital cases starting in '95. Set state standards for appointment of counsel, experience requirements, pay, compensation, caseloads, and then started reimbursing counties. It has been a very, very slow process to get counties on board, and there's a variety of reasons. But we now have about 50. See if I can get to it. You can see how we started. With first year was 5 counties. Second year, 3 more. You know, it just took a very, very long time to persuade counties, and I'll talk about the reasons why in a minute. But here's a little bit of the history of projection of the lineup, funding and appropriation, and this is one of the issues of why counties were reluctant, and especially during the period of proration. Proration is important for you to know about because there's still a myth out there that the state is not a reliable funding partner. I'll just let that sink in for a minute. In this case, it was true, because they promised 40%, but the appropriation to the commission wasn't adequate to meet the demand of the counties that were paying and asking for reimbursement. So there was a period from '02 to '09 when that was true, and in this handout there is that graph or chart which shows you how much during that period was not able to be reimbursed. The low point was, instead of 40% back, they got 25.1% back. That ended 8 years ago, but counties still say, well, what about prorating? Say, okay, that did happen. There was a period where the funding was inadequate. It has not happened for 8 years. We go back every 2 years to tell the legislature we need more money. There's more counties coming in, or the counties are spending more. This last year, the county increased the appropriation to the commission by $3.5 million. It's now up to $25.75 million. That is, considering when we started at $650,000, that's a pretty significant increase. But there's still only 57 counties in the system. There's still 35 that have elected to leave the money on the table and not ask for reimbursement. There's a map in your materials. This will show you the counties that are, the blue is in the reimbursement system. The white are not. The light green counties that qualified and then dropped out for one reason or another. Some of them dropped out during their prorating period and have never reapplied. Some thought that it was too complicated to comply with the quarterly reports that have to be submitted to the Public Defender Commission requesting the reimbursements. And some, I'm not sure why. There was one that just said it's not worth it. Yes, sir.
So who decides if a county is in the program?
Thank you so much. Question was, who decides? I didn't pay you to ask that question, did I? No. Okay. Thank you. I'm going to get to that in a minute, but let me finish a couple slides because it's about 2 slides down here. This is a chart that's also in your materials that will give you the funding history and give you the progression. You know, each biennium budget year, we have to go back and kind of project what we think is going to happen in the next 2 years. And so lately, the last 8 years, they've been pretty responsive. And the more counties that opt into the reimbursement system, obviously the more stakeholders and the more legislators then are invested in making sure that this fund is adequate so that you get your full 40% back. We're now at a point where we got pretty much of a critical mass. The 57 counties is probably about 70 to 75% of the population. So in terms of the legislative representation, we're in pretty good shape. So in answer to your question, sir, who decides? County decides. Okay, not the state. County option, right? So first thing is, I doubt that you can read this back there because it's way too small even from up here. I think it's hard to read. But it's in statute. Here it is, and then if you have the PowerPoint slides, you'll have these statutory sites. It starts with the county commissioners. The county commissioners, if they adopt an ordinance creating a 3-member county public defender board, that's how it gets started. That 3-member county public defender board, 1 is appointed by the county commissioners. 2 are appointed by agreement of the judges with criminal felony and juvenile jurisdiction. Judges can't appoint from the same party, which in some counties makes it difficult to find 2 people. We didn't think about that when we created it. If we had looked, at the map and thought about it, it was like, oh, this isn't going to be so easy. And it can be terminated. It's up to the county to elect to kind of start the process, but at any point they're saying, no, we want to pull the plug. They do it by passing an ordinance, terminating the board, giving judges notice. So the board, what do? Their job is to prepare a comprehensive plan that they submit to the State Public Defender Commission. And they have 3 choices. They can create a county public defender office. They can do a contract system, which many counties have had and still continue to have, a contract with an attorney or a group of attorneys. Or they can do a case-by-case appointment. And there's still about, I think, 20 counties that still do appointments on a case-by-case basis and are paid on a case-by-case basis. And about 1/3 of the counties now have a public defender office, just to give you a quick kind of a profile of the state. They submit the plan to the commission. The commission reviews it. If it's in compliance with their standards in terms of addressing caseload, compensation, experience requirements of the attorneys, then they approve the plan, and that triggers the point where the county is eligible for the reimbursement once the plan is approved. And then the counties submit quarterly statements to the I don't know if I have that up here or not. Yeah, goes to the auditor. Auditor certifies their expenditures for the quarter, sends that to the Public Defender Commission. They review it. Their staff kind of does a real quick audit saying, does it look like these expenses are in compliance with the standards? If so, they authorize the reimbursement. That's what the commission meets 4 times a year. The past one a few weeks ago, where I think we authorized a little over $5 million back to the counties. And that's about it's been running about $20 to $22 million a year. So actually, the appropriation now is little in excess of what is needed for those 57 counties. So it's going to be building a little surplus because it's a non-reverting account.
On your chart, how far from 2017 are you on the
Half. For Monroe County, we're probably only 1/4 in. Oh yeah, because they meet 4 times a year. So they met at the June meeting. They reimbursed expenses for the first quarter. So it's almost always a quarter. That's going to be a quarter behind.
I have a question.
Yes.
Is there a downside to White County won't be involved? Is it cost neutral or is it cost negative?
The question is there a downside, fiscal downside for a county to be involved, or is it cost neutral? It can be, in order to, if your caseloads are so excessive now that you're going to have to add a number of attorneys to be in compliance, it's possible you'll have to spend more than you do now. But that has been a rare exception. Almost always it's a net gain for the county. And, yes, sir.
Larry? Mark, can I answer that question? The reimbursement, I'm a public defender and our county is in this. Reimbursement is not just for your attorneys, remember. It's for secretary staff. It's if your attorneys, if you pick a plan and they get into your health plan, it's for their share of your county's health plan, the premium the county's paying. It's for electrical, it's for office supplies, it's for everything. So you would really have to go out and hire a whole bunch of attorneys to, within at least a couple of years, not see it really give you a significant return on your investment. We've done it for 10, 12 years now, and I don't know how we would continue not to do it, frankly.
Spoken as a public defender.
Right.
Yeah.
First time I've ever heard it.
I'd be-
Why in the world are we there? Why don't we have it?
I would be glad to talk to you about it. There's another question back here.
I'm just curious, can you explain why about 15% have withdrawn from it?
Yes, thank you. The offsetting amount, is that what you're talking about?
Well, they were in and now they're out.
Oh.
They're green.
Why they withdraw? Some counties withdraw for political reasons. Sometimes it's a judge who doesn't want to participate. Sometimes the judges and the council get crosswise. It's almost never because of fiscal reasons. I mean, an objective, it's going to cost too much to comply. The reasons that counties don't come into the system, besides they don't know about it, and nobody has told them, which probably is much our fault as anybody's. But I can tell you that as one who has proposed legislative change for creating a statewide public defender system for 40 years, every time I propose a statewide public defender system, the people who come to testify against it are judges and public defenders who do not want to change the current system. The status quo, they're vested in the status quo. Some of them, they have jobs, you know, that's their economic livelihood. Any change is threatening. And there's not a constituency out there that really cares about whether poor people get high quality representation. Let's be honest. So what's the movement for political change? And so it's easy to say, don't participate. Yes, sir.
I'm Delaware County, and our caseload is a pretty hefty one. And
Yeah.
Once we joined the commission, we had to add about 5 more public defenders. We had to increase their salaries. We had to increase the salary of the chief public defender. It's been kind of an economic wash for us if we're lucky. I'm not so sure we're even ahead on it, but it has cost us a lot more money.
Yeah, you're one of the ones that the caseloads were excessive. But But here's a reason to be looking down the road. As long as you can be in the system now and it's fiscally neutral, then you've got nothing to lose. But what we have been pushing for, and that's one of the goals that I said at the beginning, I want your help to persuade the legislature to increase state funding. This last session, we had a couple goals. One was to persuade the legislature to reimburse misdemeanor cases, because that's the one category of cases that are not reimbursed. And that makes a huge difference in many counties, to not have those reimbursed. And the other thing we wanted to do was to increase the reimbursement from 40% to 50%. So we're going to continue to push that. If we can get one or both of those, and the other issue we were pushing was we've got to increase reimbursement in CHINs and termination of parental rights cases, because those cases are doubling and tripling in some counties, in large part driven by the opioid issue, because about 50% of the CHINs cases, there's a substance abuse issue with the parents. And those cases are skyrocketing, and the cost is all on you. So we're trying to increase. So if you can help us down the road get increased reimbursement, then you'll be way out of the fiscally neutral category, and you'll have a positive net fiscal gain from that state reimbursement.
Is it possible to get into the process far enough to determine what the financial situation would be before making a decision on joining the
That is such an excellent question. I could not have phrased it any better. The question was, can you get in the process, explore the fiscal impact before you decide to commit, right? Yes, and that's what I encourage you to do by contacting the staff of the Public Defender Commission. And the names of the people, the staff, are on the last slide of the PowerPoint slides. What they can do is get the data from your county as to your caseloads and the expenditures, and then do a fiscal assessment of, do you have to add more lawyers to be in compliance? And cost out what it would cost you to come into the compliance with the system, with the standards, and then calculate the amount of reimbursement to you, give you that information and say, it's your call, but this is our fiscal assessment of is it going to be fiscally neutral? Are you a net gain, or is it an out-of-pocket loss? So you can ask them to do that before you do anything else. The county commissioners don't have to adopt an ordinance to do that. Just get the fiscal assessment. I can't say that that everybody is going to be a net benefit, because if you're really, really out of compliance, you may have to do some upfront out-of-pocket. And the commission has worked with counties even in that situation. They're saying, okay, maybe we could phase in compliance. Let's do a couple of the courts where we can get them in compliance with maybe adding a couple lawyers. You get those quarterly reimbursements, put that money into the county supplemental public defense fund, which is non-reverting, and then use that money to pay for some new public defenders in some of the other courts to get them in compliance. So you don't have to front all of the money to get in compliance. As long as you have a plan for getting all services into compliance, the commission will work with you to figure out how can we do it based upon the fiscal assessment that is done. So that's why I encouraged, as one of my goals was to say, I encourage you to, if you're in the 35 counties not in the reimbursement system, at least you should be exploring what's the fiscal impact in my county, and then talk to the other people. And anticipate in some of those counties, you're going to get judges who are saying, we don't need this, right? Because who controls the public defenders when they're under the inherent authority of the trial court? Judges, right? They're at-will employees of judges, okay? Which I have been fighting for 40 years, saying that is not a healthy situation, right? Where you're going to have to say, I didn't get a fair trial, and the reason I didn't get a fair trial because my boss, the judge, made mistakes in rulings, right? So how many of those appeals do you think happen? And it's easy to think about, would we ever allow a judge to hire a prosecutor? Or a prosecutor to hire a judge? No, of course not. Why do we allow judges to hire public defenders? Because that's the way we've always done it. I mean, We should have changed it a long time ago, but we didn't. Yes, sir.
I'm in LaPorte County, and I was previously on the Public Defender Board, so I know what you're talking about. In LaPorte County, it works out very well. We have a Public Defender office, but he doesn't have an office. He works out of his own law firm, and he uses his own staff. And fortunately, he doesn't even take salary for it. But we have 17 or 18 contract attorneys, but they're part-time, and they get paid the same as part-time prosecuting attorneys. So and it works well within the county. And our public defender fund increases every year.
Yeah, actually, LaPorte was one of the early counties. You folks have been in it for a long, long time. So that's what I encourage you to do. It's contact the commission staff, but also, you know, if you look on there and see which counties are of similar size to you that are in the system, talk to the people from those counties. They're probably your best source of trying to figure out, is this something we should do or not?
Is there a particular committee in the legislature that we need to approach whatever about increasing?
Is there a particular committee in the legislature that you should contact about increasing appropriations? Yes, in the House, it's the House Ways and Means Committee, and in the Senate, it's Senate Appropriations. That would be Dr. Tim Brown on the House side, Chairman of the Ways and Means, Luke Kenley on the Senate side, Senate Appropriations Chairman. Now, you know, this upcoming session is not going to be a budget year, but it doesn't mean you can't help, because there's an interim study committee that's going to be meeting October probably. And two of the issues that have been assigned to that committee is, one is the reimbursement from the commission in misdemeanor cases, and the other is the reimbursement in Chins cases. What do we do about the explosion of cases in Chins cases? So it would really be helpful if you've got a legislative committee to help participate in that interim study committee and have a voice from the counties as to why increased funding is important. Yes, ma'am.
I would just advise anybody that is going to be a part of this, if you have a board, to make sure that you pay attention to the number of public defenders you have and the caseload that each one says that they will hold. We're currently in the middle of a lawsuit that an attorney has picked up and found some defendants from, I'll just leave it there. But anyway, found some people who signed on to it saying that they would be a part of this lawsuit because they're accusing county and they're suing us, council, for saying that we haven't provided enough public defenders based on the caseload that each one said they would have. So just be ahead of the curve, since we're behind it. Be ahead and make sure that you have enough public defenders for the caseloads that you're saying will be there.
Are you from Johnson County or Allen County? There's lawsuits in two counties, Allen County and Johnson County, suing public defenders, the county council, county commissioners, and judges. So beware that this is a really good time, if you're not in the reimbursement system, that you might think about, if for no other reason than the CYA. Because these lawsuits are going to continue to grow. It's a national movement.
Aren't you allowed to use a portion of your budget to hire outside defense if you don't at that particular time have enough full-time staff?
Yeah. Can you use the reimbursement money to hire outside staff if you don't have additional adequate staff? Yes. The reimbursements, they come to the county. They come to the county general fund, but there's nothing that, and that means you can spend it for anything you want in the county. It doesn't mean that you can't deposit that into the county supplemental public defense fund, which is a non-reverting fund, and then that's the pot you could use to add services as you need them to comply with the standards. So there's a variety of ways you can do this. I see my time is up, so I want to thank you all for a very lively discussion.